Hi, I'm Nigel Barmer, Research Director at the Victoria Law Foundation, and the VLF and UCI Law's Civil Justice Research Initiative welcomes you to the final session today in our International Access to Justice online forum. I'd like to begin by acknowledging the traditional custodians of the land on which we meet today and recognise their abiding connection to this land, its waterways and community. The office of the VLF and my own home is on the traditional lands of the Wurundjeri people of the Kulin Nation, and it's my privilege to pay respect to their elders and to all generations of Wurundjeri people who have nurtured this land over 50,000 years and continue to do so today. I also welcome elders and community members from other nations with us today. So welcome to the third and final session of the second day of our forum, which is on courts and COVID-19. Some brief housekeeping. Only panelists can be seen and heard in this webinar. All attendees' videos are turned off and the audio is muted. But please use the Q&A function to ask questions or upvote other questions. There'll be time to get to these as the session progresses. We're recording the session and we'll distribute it after the event. So, as we all know, courts have gone through massive change as a result of COVID-19. In some jurisdictions, this was planned, but it's accelerated quite significantly, though much of this change was simply imposed. So what's happened, what worked, what didn't, how are things evolving, and importantly, what does this mean for access to justice? So I'm hoping some of today's stellar panel are going to have some answers. And I'm delighted to introduce, firstly, my good friend Alex Mark, Assistant Professor of Government at Wesleyan University, Jane Sipant, Director of Client Services at Legal Aid New South Wales, and Rob Hoyles, Director of Criminal Law at Legal Aid New South Wales, Bonnie Hoff, Principal Managing Attorney at Center for Families, Children in the Courts of the Judicial Council of California, and they'll be joined by our facilitator, Peter Noble, who's Executive Director, Regions and Service Delivery at VLA, and a great friend of the VLF. So I'll hand over to Alex to get things underway.
Thanks so much, Nigel. And thanks to Nigel and to Emily for putting together such a stellar conference, and to the VLF team for hosting. I really wish that we could be together in person, but I suppose the reason, Nigel, that you've invited all of us to be here is directly related to why we can't be together in person. So anyway, I'm really excited to be on this panel today to share a space with folks who are doing really innovative work in a time of crisis. And in particular, I'm excited to hear about similarities and differences in the approaches we're taking across our federal systems. I'm going to turn now to talk a little bit more about my research, which focuses on trying to make sense of how state courts responded to the pandemic and the consequences of those responses for access to justice. So, the vast majority of court operations pre-pandemic were characterized by their reliance on those in the court ecosystem showing up to courthouses to file paperwork, appear at hearings, serve on juries, seek legal information, and otherwise work toward the resolution of disputes. And the pandemic highlighted the capacity for risk-averse institutions, courts, to innovate. And I'm going to use my time to overview how I am capturing evidence of these innovations across state courts in the United States. And while cataloging and describing the range of court responses to the pandemic is interesting on its own, we're also poised to say a couple of things about how courts make policy and the impact of those choices on access to justice. So in terms of court administration, we don't have a good unified theory of how procedural changes in courts are designed or carried out. We might observe more strictly hierarchical processes in some states, where we're going to observe policy being designed and implemented in a top-down fashion, with court actors being pretty constrained in the reform process. And we might also observe courts across hierarchies innovating both within and outside of guidance that is provided by their high courts and administrative offices. So this moment also gives us a better opportunity to understand how these complex processes manifest across these different systems. And in terms of access to justice, the way that courts adapted processes to work in a socially distanced remote world reflects policy changes that civil justice advocates have been calling for many years. But when courts pivoted, those who needed to access them were largely not presented with a choice of, do you want to be remote or do you want to do things in person? And when I'm thinking about court users, the majority of whom do not have lawyers, I'm also thinking about how they are confronting a procedural environment that is probably much more complex and dynamic than what existed before, which presents another set of challenges. So responses to the pandemic, thus, they also challenge us to think about the trade-offs that are associated with these procedural changes that are brought about by the pandemic. So I want to very briefly overview some examples of policy choices made in response to the pandemic that we've observed through a collection of nearly 26,000 documents, which represent a year of court orders, pieces of guidance, PowerPoints, signs on doors from state judiciaries, from trial courts all the way to state Supreme Courts. And I'll focus on some data that we've processed from the first couple of months of the pandemic. And this data collection effort is also going to turn into a public-facing database, which we're piloting right now. And it's going to allow court users and civil justice advocates to do their own research on topics that are interesting to them related to pandemic-related policy change. But as it turns out, when you're collecting 26,000 documents, it takes some time to process them. We've developed some innovative strategies to describe what is contained in these documents, and I'm happy to talk more about that in Q&A. But now I want to just highlight a couple of substantive and procedural areas of interest. All right, so it's no surprise to those who are in this meeting that a major topic in these documents was about how courts would operate in a remote environment. So typical was a grant of permission like this that was sent out by the Arkansas Supreme Court. And just some things that I want to highlight about going remote. So some of the challenges from the perspective of courts included ensuring that due process and procedural requirements were met. We're also thinking here about how judges and court staff needed to adjust their behavior to make sure that they weren't disadvantaging someone because that person wasn't able to fully participate in the remote environment. And when I'm thinking from the perspective of litigants, another major concern here is if you lack internet access or a data plan that is sufficient to engage remotely, you might be excluded from virtual processes. But on the other hand, remote operations might actually make it quite a bit easier for people to access courts. Many proceedings are routine or administrative in nature, and it might take more time, both in terms of travel time and the logistics of organizing those meetings, to pull those off in person as compared to remotely. And we see this as an advantage for both the self-represented and those with attorneys. Attorneys are going to get a lot more work done if they don't have to take a 3-hour round trip to a courthouse for a 15-minute status hearing. And an early study of several hundred online proceedings in Texas suggests that we might actually see higher rates of people showing up to remote hearings. But I've been conducting interviews with judges across the country, and this might not actually be a universal trend. On some dockets, we do see lower rates of default, but in others, there hasn't been much change observed. Okay, I need to skip one of these because I'm running out of time. Okay, so I skipped over some thoughts about jury service, but I want to focus on something that I find pretty interesting, which is how the pandemic has led courts to extend procedural accommodations that they typically give to lawyers to the self-represented as well. And one such example is the relaxation of notarization requirements. So before the pandemic, lawyers were permitted to submit documents asserting their veracity under penalty of perjury. And self-represented litigants in a lot of jurisdictions were not afforded this right. And as we see from this Vermont Supreme Court document, due to concerns about the largely in-person nature of interacting with a notary, they removed their notarization standard in favor of a relaxed standard that lawyers would already benefit from. So what I think is important about procedural changes like this is that Vermont isn't coming up with a new protocol to assess truthfulness. They're merely extending the same right to self-represented litigants that attorneys may have enjoyed before the pandemic. So changes like these lead me and other civil justice scholars to question why we had two different standards in the first place, especially when the notarization requirement placed the greater burden on the people who are accessing courts who also are perhaps of lesser means. So we don't typically think of courts as places where massive change happens. And thus we have observed some resistance. And, you know, on some accounts, right, it is justified with respect to the value courts place on due process. You know, it is safer to do business as usual. But when faced with a pandemic that challenges the status quo, courts are given an opportunity to improve access to justice. We just don't have a full picture of those consequences yet, and there is certainly quite a bit of work ahead of us. Thank you. I'm going to pass it over to Rob now.
Good morning, everyone. I'm Rob Hoyles from Legal Aid New South Wales, and I'm joined with my colleague Jane Sippens. And today we're here to talk about the Legal Aid New South Wales response to COVID-19 and how we responded to the changes. I'd like to start by acknowledging the traditional owners of the various lands on which we meet. For me today, it's the Gadigal people of the Eora Nation, and pay my respects to their elders past and present. It's important in this space that we start off by talking, just to give a little bit of a background about who we are, particularly for our international guests. Legal Aid New South Wales is a statewide agency that provides legal services to socially and economically disadvantaged people across New South Wales. New South Wales being a state of approximately 8 million people. We're the largest legal aid commission in Australia and employ over 1,400 staff and deliver legal services in most areas of criminal, family and civil law. We work in partnership with private lawyers who receive funding to represent legally aided clients, and we strive to support clients and improve access to justice. In relation to access to justice, it is our duty in the provision of legal aid to have regard for legal aid to be readily available and easily accessible to disadvantaged people throughout New South Wales. And COVID has made that particularly challenging, I think it's fair to say. Just to Alex's point, and I thought Alex's presentation was really great. We have had different approaches within, even within our own state. Everyone knows that the premiers of different states disagreed in terms of how to handle the pandemic at different stages. And it's also the case that even within New South Wales, different courts took different approaches to the pandemic. As a brief example, on your screen is a photo of the Downing Centre, which is one of New South Wales's biggest court complexes, and it houses both a local court and a district court jurisdiction, and sheriff's officers are at the front door to determine who can come in. And during the pandemic, at times, different rules meant that even for the same building, different people were allowed to be admitted, depending on which floor they were going to. It's also the case that that meant that for certain proceedings, you could have a support person. For other proceedings, you could not. And so I think the sheriffs did a wonderful job at the front door of having to work out who was going where and what rules applied. One of the challenges with the pandemic was that prior to COVID-19, our primary model of servicing local court clients was that they would attend physically at court and we would take instructions from them at court. COVID-19 meant that this model presented significant risks to both those defendants and to our staff. And pretty early on in the pandemic, Legal Aid entered into discussions with court services about what steps we could take to reduce unnecessary attendance of defendants at court. It started off where people still attended court, and in a way we kind of went through 3 phases. The original lockdown, where we had very limited means to appear remotely at court, and so we did our best with technology that wasn't particularly equipped to handle the volume, particularly in the local court. Most of our staff appearing in court via AVL, mainly from our office, because at that stage our tech didn't really support them appearing in court from home. Some of the appearances were still in person, and you can see from this photo here the delineation to try to keep people physically apart. And towards the end of that first lockdown, we developed physical barriers, sneeze screens, seating, waiting areas, phone relays, and dividing people up into different waiting areas. As you can see there, some of the signage that we used to try to ensure that social distancing could be maintained. In phase 2, as the tech improved, we could appear from home more readily. There was broader acceptance throughout the whole criminal justice system for remote appearances, accepting appearances via email, accepting parties appearing via telephone. And during the Delta lockdown, which was the lockdown in New South Wales, where different postcodes fell into different areas of concern, we had to be able to come up with localised solutions, because defendants and witnesses could move around more or less readily depending on where they lived. Finally, in the third phase, when we had the Omicron outbreak, a combination of higher vaccination rates and better stakeholder relationships meant that we could maintain a much higher quality of services. And we started to ask our managers to direct clients to telephone advice, but we were able to obtain the police papers earlier and prepare matters much more effectively. So we learned a lot throughout this process, and I'll come back to that. In terms of procedural fairness, this has been a real issue with COVID, because we saw a real conflict between long-standing rules designed to afford procedural fairness to defendants, measured against the concerns presented by the coronavirus. It is the case that there has been long-standing debate about how much use should be put to audio-visual link in the court system. And I thought I would give a brief plug to the work of Dr. Carolyn McKay, who's a senior research fellow at Sydney Uni, who did her PhD thesis on the experience of inmates appearing in courts. And her book, The Pixelated Prisoner, which appears on your screen, makes for compelling reading for those interested in this space. It really highlights that the excessive use of AVL should be frowned upon in usual circumstances, as it's no substitute for an accused experience of being in an actual courtroom in many ways. But obviously COVID-19 presented a real challenge in that space, and we moved to AVL in a very, very significant way. It's really one of the challenges was that sometimes defendants, due to COVID-19, were never put before a court in any way due to isolation or staffing issues. At other times, we couldn't maintain our high standards of conferencing clients confidentially, or we would have to do it on very poor quality devices. And as we emerge from COVID, fingers crossed, it's extremely important that these safeguards are restored and that we return to models where we ensure confidential communication with criminal defence clients and ensure that they have the gold standard of appearing in court. In New South Wales, the Inspector of Custodial Services is currently conducting a review into the impact of COVID-19. And I think that will be very interesting. Legal Aid's experience has been that clients in custody have had challenges in accessing their lawyers at times, but also limited access to their family, to programs, to mental health services, and to rehabilitative services. And particularly for clients who had COVID or who were in COVID isolation, that could mean long periods of them being locked in their cells with very limited access to anyone or any other services. And that has been a real challenge, because I think corrective services in New South Wales, I think, have done a really good job of keeping COVID out of the jails. But it will be interesting in the longer term to see the impact that this lack of access has had on clients' ability to rehabilitate, for example. One of the real successes has been new solutions to old problems. And for example, police papers has always been something where we have struggled previously to come up with solutions. And it's one of the reasons why most of the advice we provide is physically at the court. But during COVID, we've been able to achieve incredible success through collaborative problem solving, and worked with New South Wales Police to put in place an automatic police papers system where the police papers get sent to legal aid at the time of charge. And that enables us to engage with these clients remotely and in much better timeframes. That was an incredible success, and police were able to push through that change very, very quickly. I will just highlight one of the risks of doing business in this kind of way, and that is that one of our lawyers conducted a sentence for a person before the local court, and the magistrate proceeded to judgment. And it was only upon the magistrate making a few comments that it became apparent that the magistrate was working off a completely different statement of facts as the defence lawyer was. So the version that had been sent through was not the final version that was handed up to the magistrate. And of course, in a real court setting where everyone is physically present, that wouldn't occur because the papers would be shown to the other party first. It's extremely rare, but it's a telling example of how we all need to be incredibly careful as we move forward into this space, because those simple things like double checking that the document is the latest version of the document is not a process that we found easy to replicate digitally. Nevertheless, it's fair to say that there are significant opportunities for the future, and that COVID has shown us that we can do things better and differently. Perhaps we don't need to wait for everyone to come to court post-COVID in order to get their fact sheets. And we're working on ways to engage these defendants before their first court date, and getting the police papers earlier is the key. Jane Sippens, my colleague, is a real key in this area, and I'm going to hand over to her to talk about who's missing out.
Thanks, Rob. I think what Rob's highlighted is the multifaceted journey that we've taken, all of us have taken. And the question that I've been charged with all along is who's missing out on every phase of the pandemic. And, you know, the obvious answer is people who don't have easy access to phones or technology, and people who need face-to-face, particularly in the surveys that we've done of clients and staff, that is people living with cognitive impairment or mental illness, and people who need face-to-face to understand or to connect with what's happening. So that could be due to hearing or cultural considerations, etc. And so that means that we always need the multi-channel options that we could talk about. But, you know, Rob was talking about how we used to do a walk-up system at court. We are always going to need to maintain some physical walk-up system at court, because there is always a significant group of our clients in particular who are not going to have access to the other remote technologies, or even the ability to arrange an appointment before court to speak to a lawyer. And we want to have both options, because those who can should, and those who can't need to be given that other option. But having our previous system was all walk-ups at court, chaotic, you know, a volume that couldn't be handled, and you know, questionable quality of advice to be given in that kind of environment. This has given us the opportunity to branch out. So in terms of considering what we're going to keep, as Rob said, we're kind of in that point right now where we're sorting that through. So really always honing our purpose. So thinking about, why are we doing this? Is this related to our purpose? Is this something that we could let go of or tighten up? So always going back to, you know, for example, that piece out of our Legal Aid Act about what is our purpose and does this match it? As I've just said, the flexible models and channels of service delivery based on client need. Also a really flexible workforce. So, and that comes into that bottom point about building surge capacity. One thing that we've really learned out of all of this is the ability to have a look at where do people need to be physically, where do our staff need to be physically, and how can we have a flexible and surge workforce that perhaps operates remotely, and that can cover some of those gaps for us. So we're looking at launching a few different services and service models at the moment. And then I think the point that Rob really went to is linking our systems across the justice sector, and we're looking at really ramping up that program, because our concern is that that collaboration that has led to, the sharing of documents before court dates has been largely based on good relationships, good collaboration at a local level. And we're a bit concerned about what might happen as we, emerge out of the COVID emergency in terms of things dropping off that are really working well. So how do we basically put in place infrastructure, systems and relationships that last the test of time, that aren't based on a crisis or personalities, and how can we embed those? And we're really at the pointy end of that right now. So I think that's all we wanted to say, and I'll hand over to Bonnie. Thank you.
Thank you. I'm Bonnie Huff, and I work for the Judicial Council in California, and I'm so happy to be with you. And I hope I will be on with you for the entire time. I actually live on a houseboat in the San Francisco Bay, and I'm delighted to have that opportunity to work at home for the last 2 years. But I will say my internet connectivity can be a little funky at times. And that has been true for many courts in the state. We have courts in very rural and very mountainous areas where internet goes out when the wind blows. And that, of course, has posed enormous challenges. I was happy, I don't know if some of you remember this opportunity for a poor attorney who was appearing in court who turned himself into a cat. But I think for many of us, the whole remote opportunity, dealing with remote and dealing with technology and a whole new way of operating has been a little bit challenging. And I think, though, that we've seen enormous progress through the pandemic. We've done a lot of training for judicial officers on how to conduct remote hearings, on how to address issues. And I think one of the things that we have found is that the emotional content for many hearings is less when it is online. For things like restraining orders or family law cases, in some ways it can actually be a little easier for judicial officers to manage those cases. When we started, the other challenge was we had a variety of platforms that people were using, whether it was Zoom or BlueJeans or Teams or any number of other things. And that was incredibly challenging to figure out how you were dealing with different platforms. But it also made providing instructions for self-represented litigants and other folks and because then we also, 40% of the people in California speak a language other than English as their native language or speak it at home. So translation becomes also extremely important. So over time, Zoom is working much better on those kinds of initiatives. So, I think we've just sort of worked through a number of those issues. So we did establish in California a work group on post-pandemic initiatives under the direction of our Chief Justice. And they held a number of listening sessions, I think 19 listening sessions with different groups, with family law, with criminal justice stakeholders, with folks from civil, and to try to identify what things were problematic and what things were working well. And they've been working on a variety of papers about what we should do moving forward. And I put the links in because it gives you the opportunity to take a look if you're interested later. So if we could go to the next slide, that would be great. So what they found is the benefits of the remote hearings is that it really does seem to promote better access for court users, that things like job constraints and childcare needs are much less impacted for folks. And I will say, having interviewed people who had taken a bus for 8 hours from one part of California to the other for a 15-minute hearing, it was painful, right? I think, it's been clear for a while that we could do better. And this has really forced us to do better in those kinds of situations. And we also have a lot of folks in California who are here for a while and then move on, and they're in another country or different state. And so it's made things much more accessible for them. They don't have to fly in for hearings and can really take care of much more of their matters, which is also incredibly important for access to justice. That there has been an indication from the domestic violence community that victims do prefer often the option of not having to be in a courtroom next to their abuser. And we can also it's easier to get expert or other witness testimony in many situations, and certainly less expensive than paying for an expert to come in. There's been an increase in virtual visitation because, of course, many people during our lockdowns, kids couldn't travel at all outside of the county. So we've seen more opportunities for people to see their kids online. And our experiences, most children are using Zoom for their classes. So they've become really, really competent and familiar with that platform. So there's a perception of increased participation and promoted efficiency in all case types. As Alex pointed out, it may vary a little bit in case types, and there are certainly challenges. And we also have a sense that many of our court users actually expect the courts to be able to operate remotely. We've got Silicon Valley, we've got the expectation that we can provide better services in that way. So if you could go to some of the challenges that were identified. Of course, the digital divide that was just identified by Jane, people who really do have problems accessing both due to their without phones or connectivity or other challenges. It's a huge issue. We are concerned that we may be seeing less folks who speak English, or fewer folks coming into the at least self-help and other programs, potentially due to the digital divide. We had court reporters that have identified that there are technology issues that result in less accurate court records. We have a very strong court reporters union in California, and they have raised concerns. We are in a process of testing remote services for the coming year, rather than just saying that we'll be able to continue to provide them, because we want to make sure that, or the legislature wants to make sure that indeed those concerns are addressed. There are also the challenges of a virtual courtroom. Do you know if, for example, in a domestic violence case, is it possible that the abuser is standing next to the person out of the camera range, or might they be children, or there might be other things that are going on that you would be able to pick up in a in-person courtroom, but not remotely. And then concerns related to criminal matters. I actually served on a jury during the last year, and we were in person. We were physically separated. We actually saw a lot of the testimony. We saw the person giving testimony, but we also saw it on camera on television screens because we were so far away from the person giving testimony. I actually thought it worked remarkably well because we had a judge who was just so skilled and also able to be able to make sure that the proceedings were available online for anybody who wanted to see it, because there was no space for people to watch the hearings. But it was quite complicated, and it was really challenging with making sure that we were far apart in the jury room and all those kinds of things. But there is a real concern with criminal cases about the constitutional rights of folks. And there was at least an initial identification of taking going on appeal because the witnesses had to wear masks. And then, of course, just the benefit of in-person services, which comes across in many, many ways. So if you could go to the next slide, that would be awesome. I work a lot with court-based self-help centers. We have attorney supervised self-help centers in every court in California. They had to change dramatically. They primarily provided one-on-one services or workshops with a group of people, can't do workshops. So we've been moving rapidly to doing much more video conferencing, whether it's an individual appointment, workshops, or online. It is very hard to review people's documents and pleadings remotely, or it was initially, and people have been sort of working it out, but that is, I think, one of the more complicated issues that the self-help centers have struggled with. But there's a lot more email and live chat, answering questions and providing forms and links to online programs and additional assistance. We're very form-based in California for many, for family law, domestic violence, small claims, other kinds of issues. So really Zoom beefed up our work on making those as easy as possible for people to complete on their own. More co-browsing, where you can give somebody access to your computer so you can both see the same thing, which can be helpful when there's confusion about what is being discussed. Lots more telephone assistance, all but, well, this is 96% of the courts are now providing answers by phone, where that was not the case in the past, partly because it's hard to take the phone when you're so busy. We provide over 1 million services a year in our court self-help centers, so they're incredibly a so we did a study on the impact of self-help services, and a lot of the data got impacted by the fact that pandemic hit, and a lot of our what's the most effective way to provide the service data kind of went out the window, but that's available. And we have a chapter on how courts address the COVID challenge in the early years. And we went basically from, very high level to a big drop for 2 months. And then we were back up to the same level of services. But we were a little concerned because, again, most of those were initially phone services, which is not generally as impactful as being able to sit down and actually review papers and go through things with people. And the next slide, if you would. So emergency rules. So there were a lot of emergency rules from the courts at the beginning, as Alex pointed out, about how different things would be handled. The judicial branch, also instituted an eviction moratorium because the legislature was not able to move quickly. And that once the legislature was back in session, that's really that's really a policy role that's much more appropriate for them. But there were a lot of emergency actions that are now sort of generally rolling off in the hope that some of the pandemic emergencies have been dealt with. We did see a big drop in filings in the early part of the pandemic, but most of our caseload is back up. And it appears that most cases are being resolved. We, again, hit a backlog when people weren't able to work. And it appears that most case closures are back up to pre-pandemic levels since many people have learned how to work some of these remotely. And if you do the next, okay. So I think for us, the major shift is that we are moving into a hybrid model, and really, I think, amazingly, trying to focus on the court user and figuring out what's the most appropriate way that person can work with the court to provide assistance. I will not promise you that this is happening across the board, but this is absolutely the direction. For some people, remote's going to be better. For others, in person is going to be better. In talking with my colleagues in the self-help world and the legal services world, there's absolutely a recognition. One of my colleagues said, never again will I make somebody take 2 buses to wait in line to find out whether they can get services. That we're doing as much as we can by phone, by other ways for people to get assistance. And I think the other final thing I would say is that I think while it's not written into any rules, as Alex pointed out, that there's much more grace that's being offered, that everybody is having problems. Judges, clerks, everybody knows the internet goes down, problems happen. And I think that there's just much more sympathy for people who are coming into court on their own and for attorneys. And I hear a lot of judges talking about, yeah, well, it's going to take a little bit longer because, they weren't able to connect, or other kinds of things that I have to say I did not hear pre-pandemic. And I just hope that we can maintain that sense of doing the best we can, giving each other grace and focusing on hearing from the people and trying to make the most appropriate decisions possible. Thank you.
Thanks, Bonnie, for that and for all of the participants. That was a great overview of the many challenges that are being experienced globally. And invite the participants to pop on their videos and invite you all to be participating in the Q&A if you'd like to put questions in there. My name is Peter Noble. I'm the Executive Director of Regents and Service Delivery at Victoria Legal Aid, and one of my roles is to support access to legal services, particularly in regional settings in Victoria, whether that be through Legal Aid's own staff practice or through private lawyers or through community legal services. And I'd particularly just like to take the moment to congratulate participants in the legal assistance sector and courts and the justice sector more broadly for pulling together during COVID and innovating, particularly in Victoria, which experienced quite tight lockdowns in comparison to some parts of the world and had to work remotely and digitally in ways and for longer than perhaps many others. That's been a fantastic overview of examples of things that have occurred globally. But I wanted to turn to a number of the comments about how to make innovation stick. Alex, I think that was your comment. Similarly, Jane, you commented that we need to make sure that systems needed to be resilient and not based on crises or personality. And they say that necessity is the mother of invention, and COVID was certainly drove the necessity to work in new and innovative ways. But I'm just interested in any reflections you have about with the I guess the most extreme impacts of COVID waning, how innovations can stick and how the drivers of change now change, and drivers like cost, efficiency, client experience, procedural fairness and safety may need to be sort of elevated more in a way that is no longer artificially created by COVID.
Is that an open question, Peter?
That's an open question to anyone to dive in.
Look, I was thinking about this because there's, in terms of trying to really shift to having some long-term sustainability around some of the things that we want to do, there's these two elements. There's kind of, I was trying to think up a clever word for it, but there isn't one. We're really focused on APIs. So those connections between systems behind the scenes. So we know how much it costs to build an API between, for example, police and legal aid, or between the courts and legal aid, etc., and not technically very complicated. So we know that we can do this stuff and it will make a massive difference. What takes time and energy, and where we get the more complex part is where the humans get involved. And so that diplomacy, so it's kind of like API diplomacy. I was kind of thinking, it's that thing about, we know we can do it, but what do we have to get over to be able to do that? So they're questions of legacy systems. First of all, we've got the problems with legacy systems. They're not all great, and we have to put layers in between them. But secondly, questions of privacy, confidentiality, cybersecurity, those kinds of things. But it's interesting because we put the lens on that we don't have in those face-to-face conversations. And I noticed there's a question relating to this, that, what privacy and confidentiality did we have before when the lawyer was talking to somebody in front of 30 people who were hearing every conversation? Like what controls did we have in place before? And now we're requiring this higher standard, and it almost being put up as a barrier. That doesn't mean I'm anti protecting people's privacy and confidentiality and cybersecurity. It's more about, I guess that's what I'm saying. There's the technology, and then there's the kind of diplomacy and negotiation that we have to go through.
Anyone else like to respond to that question about the drivers of change and innovation and how we retain the best from this period?
So I just have a couple of things to add on to what Jane has said. So a big issue for me as a social scientist is that I want to say sweeping things about how many different activities kind of generalize and squish together. And what's so frustrating about the innovation that is blossoming from the pandemic is that it really comes down to a story of having people in positions of leadership who are willing to take the helm and advocate for these changes to stick around. So I've had a big part of my project is that I'm speaking with trial court administrators and judges and clerks and lots of people who are involved in the design and implementation of these policies across the country. And it's not only, as Jane has said, you know, thinking about these legacy systems and how we are sort of like upgrading and updating and centralizing the way that we're doing things. A lot of this is also related to a shift in court culture. And that's not easy. Making cultural change is hard. And in a lot of places, I've heard both from people in these leadership positions and then also those who are mostly like frontline implementers, that the pull of what was before is really strong because what happened before was very easy to do. So I think that on one hand, it's really a who is in a position to ensure that this cultural change remains. And then there's also a much longer answer about it's very expensive to keep some of these changes around and courts are notoriously underfunded. So that's also a big problem. But yeah, so that's what I'm going to contribute here.
Rob?
Just to add on to Alex's point, I think it's almost like because of the pandemic, we've all seen changes that we like and changes that we don't like. And I think part of it is making the case for change for the things that we like. I don't think it's reasonable to assume that people are going to want to keep the pandemic things going just because we've had a go at doing them. In part because most people were told we're doing this because of the pandemic. It's an emergency. We haven't really had time to think about if this is the best way. We're just going to do it. But in doing that, we've got to trial a whole heap of things, some of which have brought about wonderful positive outcomes. And I think a lot of people would want to embrace them. But for the ones who don't, they still need to be convinced that now we can actually show this is the best way. This is how we should be doing it.
Thank you. But Bonnie, I wonder whether...
I just wanted, some of it's habit. Some of it's just going to be, you know, we broke some old habits and we, you know, like, and so for things like e-filing, I talked to legal aid attorneys in Los Angeles who just thought it was going to be impossible. And it was not designed by me. There are all kinds of problems with it. But once they've done it now, you know, for however many weeks, okay, I figured out how to do it. And I think that is going to be the case for many of the innovations is that we have become much more used to it. And I think the challenge from my perspective is that the emotional, that kindness, that flexibility piece. And I don't, you know, other than things like judicial education and leadership, talking about it, that cultural piece is much harder.
Bonnie, I'd like to stick with you, but also reference a question that's been put up. Jane, you began your presentation by saying that one of your roles is to ask who's missing out and to be asking that sort of persistently. And that got me thinking about outcomes and what we know from the process or the period that we've been through in terms of improved or diminished outcomes by all sorts of different measures. Bonnie, you listed a number, including a preference by some domestic violence victims to not come in, an increase in virtual visitation. It was cheaper in terms of experts appearing in proceedings. They're just a number. I'm just wondering if you could comment any further about any outcomes that we know through this period or where you think, you know, some further research needs to point. In answering that question, could you also think about whether or not there are formats that we've tried during COVID that are more therapeutic or anti-therapeutic. There's a question about whether or not this format is kind of more suited to more therapeutic approaches, engaging people differently, or whether or not that's kind of undermined because perhaps you have less physical proximity to someone and can't develop a relationship as well. Be interested to know what you or other panelists can.
Yeah, I can speak to that a bit, and I can also see if I can get, there's been some work done on our collaborative courts, which are often called therapeutic courts, but those are often situations where someone, for example, has been identified as having a mental health issue and thus has committed crimes in relationship to that, or has other kinds of challenges, that veterans courts, other kinds of things, that those have actually worked quite well through the pandemic. And part of it is, in some ways, it may be easier for that person to have regular contact with the players, as long as they, because those courts usually have a whole variety of social services and other support. And partly what you have is the judge being the convener to say, to be, raw, you're doing a great job, or, you haven't done the right thing and whatever. But there's usually a lot of touch points in those programs. So the person's coming into court a lot. So, that makes it really difficult if that person, for example, has a job. It makes it, being able to say, I'm taking my lunch hour to do this, or, whatever it is much easier for them. And it probably is a lot easier for the other participants who are, the social worker or the probation officer, all those kinds of things. So I think the key is whether that personal relationship can be established online. But I do think that I think it'd be great to research, but my sense is that we have a fair amount of data that people have been able to do those relationships online and are able to establish empathy. And again, watching judges, watching other people, I think you can do an awful lot. So I think that there is that absolutely that benefit. And I think part of the challenge is then identifying those people who are, sort of slipping through the cracks, and figuring out how, there's a lot of discussion about how do you do a fair hybrid hearing where somebody is in person and the other person is online, right? And we've had to work through a lot of issues with interpreters where there are all kinds of nifty things, but, making sure that the person can hear the attorney and the court, but the court isn't hearing what the attorney is saying to the litigant if they're having side conversations and those kinds of things. And I think that there has been a lot of those things have been worked out, but I do think we sort of have a ways to go with some of those issues.
Thanks, Bonnie. Would any others like to comment on the issue of outcomes or formats that are sort of more therapeutic or less therapeutic for people? Rob?
Just quickly, I know Alicia, who asked the question, works at the Neighbourhood Justice Centre, and unfortunately we don't have really interesting models like that in New South Wales. And I think to her question, we would like to see that kind of investment in New South Wales. But to that particular thing about the restorative lens, we're rolling out new drug courts in New South Wales. And one of the interesting things that the pandemic has thrown up is, would there be scope, for example, to broaden out the geographical scope that the drug court would ordinarily operate in? Because, for example, vulnerable Indigenous clients in really small communities may not normally get the opportunity to be linked in, but there may be scope. Now, for the drug court model particularly, one of the pieces of pushback is that there's heavy reliance on things like urinalysis, like ongoing testing in relation to those defendants. So sometimes the tech piece alone can't solve all of the little pieces that are needed for the actual structure of the court. But I think it's a really interesting question and an area that we should explore, because there probably are restorative or diversionary measures that operate better in the tech space that could be supported better than what we could have done pre-pandemic.
I won't be able to get to all of the questions, but there's some interesting questions about people understanding their work better and realizing how much how many matters get resolved by hallway conversations or other interactions, and not in that formal setting, perhaps of court, and the need to sort of replicate that using other messaging or other systems, and wondering what people have done to adapt. It's also a question about impact on court staff, which I think probably is something that many agencies have experienced, with people's personal spaces being intruded upon by difficult work that many of us engage in. Did anyone want to comment on any kind of experiences of that, intrusion, or any feedback from particularly court users on how they've coped? Sorry, not court users, staff at court, on how they've coped through this period, given the extraordinary backlog of matters that we've seen, and the necessity for them to adapt. Well, we're all advocates, so it's not so much our experience.
And I'll just say one really incredibly frustrating thing, and I don't know if you have it in Australia, but we have more spam calls, phone calls, than I have ever experienced, with people trying to sell auto warranty, and it's all, and it comes in, people are stealing phone numbers, any rate. And one of the challenges for court staff who were providing assistance by phone is that up to half of the calls that came in were those kind of robocalls. And and then people who really needed the assistance would be bounced out of line, or you can deal with them quickly, but it still meant this incredibly long line. It's a very odd kind of thing, but I think those kinds of things are just enormously frustrating and difficult for everyone, and impactful for court staff and other people in terms of providing assistance. But maybe you escaped that in Australia.
I saw Jane shaking her head as if to say it's here too. You're just on mute there, Jane.
I was surprised. No, we haven't experienced that. Legal Aid New South Wales hasn't experienced that. So that seems odd, yeah.
I've got a question about relationships, and whether the relationships that existed between key stakeholders in the justice system inhibited or improved the capacity to respond in the context of COVID. So I think part of Victoria's experience was a kind of dawning realization that if we did not operate as a system, then we could not function at all. And I'm just interested in any reflections about that, and whether you feel like COVID dragged people to the table to work cooperatively in ways that hadn't before, and perhaps now opens up new opportunities to work closer together. Rob?
Certainly, my experience was that, yeah, we if COVID brought a whole heap of stakeholders closer together, I think, and maybe those relationships weren't as strong at the start of the pandemic. I think when the pandemic first occurred, there was a whole lot of dawning on a lot of agencies about who do I need to talk to about this. And now we have kind of weekly sector meetings where the senior people in a whole lot of agencies get together to talk about, on a weekly basis, giving an update as to what has changed that week. And you'll have seen from my presentation, for example, the police papers thing has been a huge thing for us, where agencies get together and say, how do we solve this particular problem? It's going to need collaboration. It's going to solve problems for all of these agencies put together if we have a single approach. And if anything, I think that's gotten stronger and stronger and stronger as the pandemic has gone on. I think the relationships that we've built have been really good. And I think you hit the nail on the head, Peter, when you said they can be used for other purposes. That it's really, it has been something that's really changed, I think, the way we cooperate and we work together.
Thanks, Rob. Alex, you began your presentation by talking about the huge volume of material that you and your team are processing. I think you said 26,000 documents. I've seen perhaps hundreds of things like practice directions, guides, signage, laws, regulations, and the like. Can you give us a picture? And I can only think globally how many similar documents exist. Can you give us a picture of where that piece is headed, and what sort of insights you think it'll be able to yield over time?
Thanks for that question, Peter. So in addition to creating this database, which I hope that courts and people who sort of like, work in the court ecosystem can say, so for some reason, Alameda County is always at the top of our California list. And it's always kind of like, what's going on in Alameda County? So our hope is that if you are in New South Wales or if you are in Vermont, you could say, oh, I wonder how Alameda County was talking about evictions on March 19th, 2020. And what our database will allow you to do is to bring up those documents and compare the ways that these different jurisdictions are talking about evictions. So one of the things that I think is really great about this project is that, importantly, not everyone talks about evictions by calling them evictions. So we've used some techniques to sort of like expand our dictionary of eviction such that forcible entry and detainer and summary process and eviction are all sort of under that same net, but we can see how some of these terms aren't really accessible for the people who are using courts, and how do we think about maybe standardizing that a bit. Another thing that we're going to be working on, to your point about insights, is how is this language shared across courts? So we are starting a project where we're looking at patterns of borrowing across time and space. So how do we see patterns of speaking about evictions sort of emerge in states? Who is the first to really harness a simple set of language? And how does that kind of diffuse across different courts? So that kind of gets to that story of how procedural change evolves over time. And I think that the documents will help us tell that story in a way that we really haven't been able to investigate it at this scale before. So thank you for that question.
Yeah, no, amazing. That sort of comparisons, I think, will be extraordinarily beneficial. And perhaps Australia will work to something like that, or perhaps internationally in time. But no, that's great, and we look forward to the publication of that material and whatever other kind of machinery operates around it to help.
I'm looking forward to it too.
Sure, it's been your life for the last couple of years. Anyway, look, we are well and truly at time. I wanted to thank all of the participants for sharing generously, for the listeners being here, and also for contributing questions. And with that, I'll throw to Nigel.
Yeah, that was a great session. Thanks so much, guys. So many thanks to Alex, Jane, Rob, Bonnie, and Peter. You've given me, and I hope all of our attendees, a lot of food for thought. Tomorrow's the final day of the forum. We start with a session on climate change and legal need, then the role of legal education and access to justice, before we ask some real titans of access to justice to try and look into the crystal ball and think about what the future might hold. You can find the links to those sessions in your program, but we'll also email them to you if you've registered. So, yep, thanks again to our presenters, facilitator, and attendees, and I hope to see you all again tomorrow.